Bismillah ar-Rahman ar-Rahim wa salatu wassalam ala ashraf al-mursaleen. We are going to proceed with our lecture, Commercial Law for Business Students for Al Isra University, and we are going to start on page 179 and proceed with this title. The partnership relationship is a fiduciary one. This means that the partners are placed in a position of trust with each other, and each partner acts as the agent of the others. So they have the following duties. Number one, to make full disclosure to each other of all issues relevant to the business. Two, to declare any personal financial benefit received by a partner in carrying out the firm's business. And three, not to compete with the firm without the consent of the other partners. When transacting business on behalf of the firm, a partner is treated as its agent. Partners can act only within their legal authority and must carry out their duties with reasonable care and skill. The partners have apparent authority to carry out any transaction relating to the business. Therefore, any resulting contract is binding on the other parties, whether or not they actually authorized it. Failure to perform the contract could result in an action for breach against any or all of the partners. For example, if a partner ordered headed writing paper for the firm, the other partners will jointly liable for its cost, even though it had previously been decided by majority at a partners meeting that new supplies were not needed. Similarly, if a partner committed a tort while carrying out the firm's business, the other partners would be vigorously liable for it. A negligently performed job could give rise to this sort of liability. The partners are jointly and severely liable for all partnership obligations. As the partnership has no legal existence distinct from its members, all the partners are personally liable for its debts and other legal obligations. If the firm does not have sufficient funds, the partners have to make good to shortfall out of their own pockets. Legal action can be taken against a partnership in its own name, but the partners remain jointly or severally liable for what is owed actually. This means that if a judgment debt is not paid, it can be enforced against all of them or any of the partners. This may result in one partner having to pay the entire debt, though that partner may seek a contribution from the others. Like a sole trader, a partner may be personally bankrupt if the assets of the business are not sufficient to cover its debts. Limited liability partnerships. The law enabled the creation of a limited partnership. A limited partnership consists of two teams of partners. Excuse me. One including at least one joint partner who shall be responsible in his entire funds for the partnership's debts, and the other including at least one partner who shall be responsible for the partnership's debts to the extent of his share in the capital. This means that it is composed of a number of sleeping partners who must take no active part in running the business and whose liability is restricted to the amounts of capital which they invested. These partners running the business have unlimited liability for debts. In practice, such partnerships were e- extremely rare, as anyone seeking limited liability was more likely to seek registration of their business as a company. It is recognized that the limited partnership model is a useful investment tool. Dissolving the partnership. A partnership may come to an end for a number of different reasons. A partnership shall be ended by the death, quarantine, declaration of bankruptcy, or insolvency of one of the partners, or by the withdrawal of any partner from the partnership, if its term is not specified. Nevertheless, the partnership's contract may provide that if any partner dies, the partnership shall continue to exist with his heirs even though they are minors. Lapse of time. Most partnerships are formed in the belief that they will be continued indefinitely, but a specified lifetime may be stated in the partnership agreement. For example, two people might decide to run catering facilities for the duration of an exhibition or a trade fair. The sole purpose of the partnership is achieved. The example above is also relevant here. Death or bankruptcy of a partner. Usually, the partnership makes a provision for such occurrences, but failure to do so could result in dissolution. Illegality. If the purposes of the partnership subsequently become illegal, the partnership contract is uh, frustrated. A partnership created for the import of certain goods would be dissolved if the import of these goods was subsequently banned by regulations. Notice from a partner, unless the agreement provides otherwise, the partnership will terminate if one party decides to leave. Usually provision is made for this. Court order. A partner may ask the court to order dissolution on the grounds of mental or physical incapacity of a partner, or because of misconduct by a partner prejudicial to the business, or which amounts of will fall as persistent breach of the partnership agreement. The court may dissolve the partnership if it is just and equitable to do so. Dissolution will be ordered if the business cannot be carried on without making a loss. Public scrutiny of partnerships. Unless the partnership is unlimited liability partnership, its affairs, unlike those of a registered company, are not subject to any more public scrutiny than those of an individual trader. Relevant tax returns must be made, and the planning requirements of the local authority concerning business use or the premises must be met. Members of the public have no right to inspect the accounts of the partnership, and there is no legal duty to audit them. If a business name is used in the names of the operators, the names of the uh, proprietors must be displayed at the place of business and on any letterheads of business stationery, which re- repealed and replaced. This enables customers to traders to ascertain the identity of the people running the business.